Now, let's bring in members of the legal teams on both sides for a sense of the trial that won't happen. Neil Bruntrager, who's an attorney for police officer Darren Wilson, and one of the lawyers for Michael Brown's family, Darrell Parks. Mr. Bruntrager, before we get to the shooting, I want to talk about the breaking news. Why did Darren Wilson decide to resign from the Ferguson Police Department, and does he still fear for his life?
He decided to resign, Chris, because we got information yesterday directly from the chief in Ferguson that they had some information that suggested there were going to be acts taken against either members of the department or the department itself related to his continued employment. And when Darrell was told that, he simply said that's enough, and it was time to resign. And so he filed or submitted an oral resignation followed by a written resignation letter shortly thereafter.
Does he still feel he's in danger? Does he still feel he's a marked man in the St. Louis area?
He does, Chris, and it's a shame, and that's something he's going to have to live with for quite some time.
All right, Mr. Parks, let's get to the evidence in this case. What do you think is the single biggest hole in Officer Wilson's testimony? What do you think is the strongest reason that that grand jury should have indicted him?
Well, Chris, I believe the strongest reason is the reasonableness of his so-called fear as Michael approached him. From what I can tell thus far in my investigation of this case, almost all of the gunshots that Michael received, he could have lived from, except for the headshot. And so the headshot, the kill shot, was to the apex of his head. It is my opinion that, given the fact where his head was positioned at the time of that shot, that this officer had other reasonable means that he could have subdued Michael and failed to do so.
Mr. Bruntrager, let me pick up on that, because there seems little question that Michael Brown, from the forensic evidence, that Michael Brown attacked Officer Wilson in his car, grabbed for his gun. But here, I think, is the question that a lot of people ask. Why did Wilson get out of the car and follow Michael Brown? Why not just stay in his car, follow him if need be in the car, and wait for backup when there'd be more people and they could subdue him without a shooting death?
Well, the information that we have is that Michael Brown, immediately after the shots are fired in the car, immediately after the scuffle in the car, Michael Brown takes off. Michael Brown's running away. Darren Wilson's job is to keep his eyes on Michael Brown. And he has said, both in his statements on August 9th, on August 10th, in front of the grand jury, in his statements to the feds, he has said to them, listen, the reason I got out of the car was not to arrest Michael Brown. He didn't believe for a minute that he could subdue Michael Brown by himself. His job, getting out of the car, was to keep eyes on him. Wherever he went, he had to see where he went,
sir,
because he believed that Michael Brown posed a threat to others.
Why not just follow him in his car and wait for the backup?
Well, because what if he gets off the road? What if he gets into the neighborhood, which is exactly where he was going? You can't follow everywhere in the car itself.
Mr. Parks,
and his job is to keep eyes on him.
Well, a couple of problems, Chris. One, when the officer got out of the car, witnesses have testified that he continued to shoot at Michael as Michael was running away. And there also
wait, he wasn't shot. Wait, Mr. Parks, he wasn't shot in the back. He was shot in the front.
Okay, but let me say this here. Just because you're shooting at him doesn't mean you have to have hit him, Chris. You're confusing two things, and that's part of the problem that's happened in this case, that just because I shoot at you, it's obvious that a few of the shots that the officer shot missed him. It is possible, though, that one of the shots to his arm could have possibly come from the back. So, I think we don't need to confuse the two things. Yes, witnesses say he shot at him. He may have missed him, right? But at some point, Michael turned around, and even the officer testified as if his body had jerked, as if he had been hit. So, although people glance over the aspect of the fact of what made Michael turn around, he didn't just turn around by happenstance. He turned around because he had been hit, and the witnesses further testified that Michael said, "Hey, why are you shooting? Quit shooting." And
well, let me bring in Mr. Bruntrager. Was he turning around to give up, or was he turning around to attack Officer Wilson?
He was turning around to attack Officer Wilson. Look, Chris, everybody has a right to their opinions. They don't have the right to their own set of facts. So what we know, in my mind, the single most important piece of evidence is the blood spot that's about 25 to 35 feet away from his body. We know that he went to a farthest point north because his blood is there. That's irrefutable. There's no question. He has come back towards Officer Wilson, and that's when he is shot. When he is shot, he's about 8 to 10 feet. In the final shot that Mr. Parks referenced, he's about 8 to 10 feet from Officer Wilson. We call that the kill zone. At 8 to 10 feet, he can reach Officer Wilson. And Officer Wilson has indicated to everyone that will listen that he believed that Michael Brown intended to kill him.
Right,
now, look at the shell casings on the ground, too.
Let me just pick up on this because, Mr. Parks, Missouri law is pretty clear, and what it basically says is that a police officer is entitled to take deadly force if he, quote, reasonably believes his life or someone else's life is in imminent danger. Here is what Darren Wilson told ABC News.
At that time, I gave myself another mental check. Can I shoot this guy? Legally, can I? And the question I answered myself was, I have to. If I don't, he will kill me if he gets to me.
Mr. Parks, doesn't what you just heard there from Officer Wilson, doesn't that meet the legal threshold for an officer being allowed to use deadly force?
Well, Chris, let's not confuse two things. Number one, and I know we're going to deal with the issue of the grand jury's actions later in the show. However, that's a defense, whether or not his belief is reasonable. We believe that, number one, there should have been an indictment. There's enough here without question that this officer should have been indicted. Number two, if you're going to issue or have that defense, which is fine, have that defense before a jury so that the evidence can be properly presented by both sides in the case. We do not believe that the manner in which this was handled, where you have a prosecutor's office, both one putting on the evidence to indict, but also putting on other evidence that puts forth the possible defenses or actions or justifications in the case. You can't have it both ways. That's not how this process should work.
Mr. Parks, let me pick up on that, because you have called the decision not to indict, in your words, a travesty, and this prosecutor did something unusual but not unprecedented, which is that he simply presented all the evidence to the 12 grand jurors and let them make up their mind. Why does the prosecutor have to seek an indictment? Why can't he just leave it up to the grand jurors?
Well, without question, I mean, I think given the fact that you have this process where he goes in, if he goes in and one just gives him all the evidence, I mean, it's not as if he's put in a posture to get an indictment. I mean, from his action, it appears that he does not want an indictment. Thus, they don't indict. When a prosecutor wants an indictment, a prosecutor puts forth the evidence that is that will line up to give an indictment from the grand jury. And the prosecutor, by his actions, whether verbal or nonverbal, indicates to the grand jury that I want an indictment in this case. It is rather clear in this case that that was not the case in this case. Thus, that's why we should not be surprised by the fact that there was no indictment in this case.
Let me bring in Mr. Bruntrager, because the fact is that the legal standard in grand juries, which is probable cause, is a pretty low standard, and generally speaking, grand juries are instructed to indict if there is, quote, some evidence of guilt. Didn't they reach that standard? Obviously, the jurors didn't think so.
No, they didn't. But look, when you look at the Missouri statutes regarding grand juries are formed for a number of reasons, one of which is investigation. They can be called to do just what they did here, and that's to look at all this information and decide. I find it astonishing that we have criticism of this grand jury because people say they were given way too much information. They were given way too much to think about. Now, these grand juries operate in an entirely different way than what we call a petit jury. That would be a trial jury. They're given the opportunity to look at information. They can then leave. They have sometimes a week between sessions. They can ask questions if they want, unlike regular juries. I mean, this grand jury clearly looked at everything. They asked questions. They were engaged. I don't know how Mr. Parks says we get in the head of the prosecutor by perhaps some means to sort of figure out that impliedly they didn't want an indictment. I don't see that. I've read these transcripts. What I see is a prosecutor who put all of this information in front of a grand jury and said, you decide.
Gentlemen, I got time for one more issue I want to get into with you. Mr. Parks.
Chris, if I may, though, Chris, important issue. We're not indicting the grand jury. I don't blame the members of the grand jury for what it resulted here. I think the process was flawed that was laid out by the prosecutor.
Okay. Mr. Parks, is the Brown family, which you represent, are they going to file a civil lawsuit against Officer Wilson? And if so, on what grounds?
Well, Chris, obviously they have the option of a civil lawsuit, one upon civil rights basis against Officer Wilson, two against the Police Department in the city of Ferguson, if that time comes. Those are not issues that we discuss publicly upon our team. We will certainly give the parties a chance to work that out among the parties if they choose to. If and when we need to make it a public issue, we will. But as of now, it is not.
When you say give the parties a chance to work it out, are you suggesting a possible settlement?
No, I mean, I think there's a chance to resolve whatever differences we may have. That could be a settlement. It could be some form of litigation if needed. But it just depends. I mean, they'll have a chance to do whatever they deem proper in the situation, and we'll react.
Finally, Mr. Bruntrager, reacting to that, what do you think of the merits of a civil lawsuit by the Brown family against your client? And also, what do you think of the merits of a federal lawsuit, if they decide to bring it, which would have to prove that Officer Wilson intended to violate Michael Brown's civil rights?
Let me start with the latter. You've got a situation where we know there's still an ongoing federal investigation. If the feds had decided that they were going to bring, if they do decide that they're going to bring an action against Darren Wilson, it would have to be some sort of allegation that he violated the civil rights of Michael Brown. In order to do that, you have to show that he intended to violate his civil rights. So it's not just that you intend to pull the trigger, it's that you intend to actually violate his civil rights. That's a pretty high bar. That's going to be a difficult thing for them to do.
And what about the civil lawsuit?
Particularly in light of the fact, well, the civil lawsuit's an entirely different question. I mean, in most instances, it's really not directed to the individual. It's directed to the police department itself for a variety of reasons. Again, I think that they're going to have a difficult row to hoe, but every American has a right to seek redress in the courts, and of course, I would never begrudge that to anyone.
Mr. Bruntrager, Mr. Parks, we want to thank you both so much for joining us today.
Thank you.
Thank you, Chris.